Today I have the pleasure of introducing our keynote speaker, Jeff Sutton, who I first met 25 years ago. He told his side of this story a few years ago when he delivered the Barbara Olson lecture at the National Lawyers Convention of the Federalist Society. Now I can tell my side of the story and along the way explain Jeff's background and why he is the perfect speaker for the inaugural State Chapters Conference in Alabama. In 1997, Jeff and I served as panelists for a discussion of recent decisions of the Supreme Court sponsored by the then new Practice Group for Federalism and the Separation of Powers in Washington, D.C. I was the new Attorney General of Alabama. He was the Solicitor General of Ohio. Our now mutual friend, Greg Katsas, now a judge on the D.C. Circuit, and Professor John Duffy, now at the University of Virginia, also participated as panelists. As Jeff has explained, it was supposed to be a friendly discussion among conservatives. But as often happens at a Federalist Society debate, our discussion didn't go according to plan. We ended up sparring with each other. Jeff started his presentation by arguing that the Supreme Court was right in 1973 and Rodriguez versus San Antonio Independent School District to leave questions about the funding of public education to the states. So far, so good. But then he went off the rails and argued that state courts should instead tackle the tough questions about adequacy and equity in the funding of public education by interpreting their state constitutions. That pitch triggered me. When Jeff suggested that state courts were better suited to tackle the subject of education funding, I objected. I called it judicial activism and argued that it was wrong regardless of whether federal or state courts engaged in it. Jeff understandably expressed surprise because he was trying only to make the modest point that state courts were in a better position than federal courts to address the issue, but I was having none of it because I argued neither federal nor state courts should intervene. We were both tackling that issue in our public service, but we were in different predicaments in our respective states. Jeff, on the one hand, had been defending Ohio in long-running state litigation about public education funding. I, on the other hand, had been urging the Supreme Court of Alabama to end similar but more recent litigation in our courts. Jeff's courts had already decided that they were going to exercise jurisdiction over the subject. Our courts had not settled the issue, and the political debate was ongoing. Eventually, the Supreme Court of Alabama did the right and courageous thing by ruling, as I urged them to do, that any remedy for inadequacy or inequity in funding public education was non-justiciable. In Alabama, this matter rests as it should with the legislature, governor, and state board of education. In addition to our different predicaments, Jeff and I, though we both revere the structural constitution, probably differ a bit in our first priority. Jeff has always been foremost an evangelist for federalism. Indeed, he has written 2 books on the virtues of federalism and state constitutional law and a casebook on the subject. I've always been foremost a defender of the separation of powers and have taught federal jurisdiction and textualism for many years at the University of Alabama School of Law. Jeff regularly teaches at Ohio State, his alma mater. As a side note, a few years ago, we hosted each other for a home and home series. He took me to a fabulous game between Penn State and Ohio State in 2017 at the Shoe, where the Buckeyes' 1 point come from behind victory in the last minute of the game helped Alabama make and win the college football playoff. In gratitude, I later hosted him for a beatdown of Texas A&M in Bryant-Denny Stadium. You should come back, Jeff. We're going to do that again this year.
Anytime.
By the way, Jeff and I are the only ones who remember our disagreement in the panel discussion 25 years ago. The more memorable part of the event happened when, as then a politician, I ended my prepared remarks with a prayer for a future Republican administration. Please God, no more suitors. That would later become one of many controversies in my confirmation hearing in 6 years. Jeff once told me he suspected I regretted offering that prayer. I told him no. I was happy God answered it. After our public spat, Jeff and I became allies. Jeff returned to private practice and, at my request, agreed to represent Alabama in 3 major cases about issues of federalism and the separation of powers in the Supreme Court of the United States. Kimmel versus the Florida Board of Regents, Garrett versus University of Alabama at Birmingham, and Alexander versus Sandoval. As a former law clerk to Justice Scalia and a former state solicitor, Jeff enjoyed a great reputation at the Supreme Court because, candidly, he is a great lawyer. We won all 3 cases. Jeff also filed persuasive amicus curiae briefs. That's the right way to pronounce it. I took Latin because I went to a Catholic school for us in other cases, including United States versus Morrison, where the Supreme Court ruled, consistent with Jeff's argument, that part of the Violence Against Women Act was unconstitutional. Notably, 36 states filed an amicus brief in support of the federal government in that case, but Alabama, with Jeff's help, filed a brief alone in taking the side of a rapist, a challenger to the exercise of federal power. Jeff's successful representation of Alabama in so many cases before the Supreme Court led me to create a Solicitor General position. He also suggested that Kevin Newsom contact me, which eventually led me to appoint Kevin to serve as our Solicitor General. So my judicial colleagues who previously served in that post, Kevin, Andrew Brasher, Corey Mays, along with John Nyman and Eddie LaCour, the current solicitor, can thank Jeff for paving the way. Jeff's success in representing Alabama also got him into trouble. When President George W. Bush nominated Jeff in 2001 to serve on the Sixth Circuit, Jeff's opponents pointed to the unpopular positions he had taken in those cases before the Supreme Court, where Jeff had argued that many of the laws Congress had passed were unconstitutional. Facing Senate confirmation by many of the senators who had sponsored or voted for those laws, Jeff proved again that he is a great lawyer. How did he do so? Well, Jeff blamed the client. Me. He told the senators that as an advocate, he was only adhering to his ethical obligation to represent his client zealously, and it worked. Incidentally, after the Senate confirmed Jeff's appointment, the president nominated me to serve on the 11th Circuit. Now, with the client in Jeff's cases seeking confirmation, I did what any good politician would do. I blamed the Supreme Court. After all, the court ruled that we were right. We won all the cases. Our parallel paths have continued. Jeff now serves as Chief Judge of the Sixth Circuit, as I serve as Chief of the 11th. The Chief Justice has also appointed Jeff to serve on the Executive Committee of the Judicial Conference of the United States, along with Alabama's own Judge Scott Kugler. The Chief Justice appointed Jeff earlier to serve as a commissioner on the Supreme Court Fellows Commission, where I served briefly as an ex officio member when I was acting chair of the Sentencing Commission. We have served as co-authors of a treatise on the law of judicial precedent. I know Justices Kavanaugh and Gorsuch were honored to serve as co-authors with us. And Jeff's Jeff's son, Nathaniel, is one of my law clerks this term. Our long relationship would not have been possible were it not for the Federalist Society, which sponsored the program where we first met. Critics of the Federalist Society portray it as a secretive cabal with a nefarious political agenda, but nothing could be further from the truth. The Federalist Society is what it says, an organization devoted to reasoned debate about the Constitution and the rule of law. It declares that the separation of powers is central to our Constitution, and that it is emphatically the duty of the judiciary to say what the law is, not what it should be. Everything else really is up for debate. And its success in bringing lawyers and judges together to discuss these topics has succeeded in transforming our legal culture. This conference is a continuation of that effort to change our legal culture. So, please join me in giving a warm Alabama welcome to our keynote speaker, Chief Judge Jeff Sutton.
Well, this is easily going to be one of those situations where the introduction is way better than the talk. I still don't know why you hired me. I mean, I thought you were crazy. You thought I was crazy. I still think you're a little crazy. I'm quite confident I'm going to trigger you several times today. And you triggered me. I was writing things down already. I do want to just emphasize the Federalist Society point. Yes, it happens to get a lot of conservatives, but it is a debaters' society. I just don't understand how the rest of law, the country doesn't want this. How do you get more intelligent without having your ideas challenged? And we've been doing that to each other for the longest time, and it's part of our friendship. And I just don't understand people that think it's really fun to go to a place where you all say the same thing, and it's like a really bad church. I mean, it's just not interesting. They're not saying anything new. They're not provoking you. They're not making you think. And here, the whole point is to debate, say provocative things, test ideas, get judges to be told maybe they're wrong, have judges tell lawyers maybe you're wrong. It's just wonderful and good for Alabama in having this conference. I want to point out one thing, that you started out with a state court judge, which is a great way to start anything. And you're ending with a federal judge who wants to become a state court judge. So that gives away a lot of my remarks. I'm a huge fan of the state courts and state constitutions. I do want to respond to just a couple things. You did suggest, you were polite about it, it was an introduction, but you've suggested more directly in the past that I was not the most loyal lawyer, because when I get in front of the Klieg lights of the Senate Judiciary Committee and I'm trying to become a federal judge, I just throw the state of Alabama overboard and I say, hey, it's Alabama's choice what they want to do. I'm just the lawyer, and I represent murderers. I said this in the confirmation hearing. I mean, what's your implication, Jeff? So I was really bad. But I was a loyal lawyer, and I want to prove to you all, I was not only lawyer to the state, to General Pryor. We worked so hard on those cases. But I want to ask you, anyone in this room, there's a lot of Bill Pryor friends in this room, but anyone in this show more loyalty to him in this sense? My wife and I have brought individuals in the world just to clerk for him. No one can say that. So that is lawyerly commitment. And I got a client for one, they're a client for all time. And if it means more children, we'll have more children. No problem here. I'm only going to say one nice thing about you, Bill, because I don't want to go any further than that, because it undermines my credibility when we disagree later. But your secret, the thing I've just always admired about you, I'm so thrilled my son is clerking for you, is, what do they say? The virtue that starts all virtues is courage. And you may be a little crazy with your courage sometimes, but I don't know anyone more courageous than you. And I just feel like that is at the center of why you've made such an impact on American law. I really agree with it, and I think one reason I appreciated it is I'm milquetoast. I'm milquetoast. I'm like, no, let's run for the hills, and I've just always admired that about you. In the U.S. versus Morrison case, that solo state amicus brief who challenges the Violence Against Women's Act and is an elected official. Well, it turns out just one person in American history. Everybody else ran for the hills. It was, I will say, a fun brief to write because we were able to say, do you really think the state of Alabama does not care about violence against women? In fact, the U.S. Supreme Court has limited us in making sure that there is not violence against women. What did we used to do? Execute rapists. And the U.S. Supreme Court in Colker versus Georgia said that violates the Eighth Amendment. So it was really fun to say, violence against women, we'll do everything we can if the U.S. Supreme Court wouldn't get in our way. So that was the only thing we could say to kind of cut against them. But anyway, I admired you for signing that brief, and I was very proud to be the lawyer on that brief. So my topic is 4 laments of an originalist and how state courts and state constitutions can help us deal with these laments. So lament number 1 for a thoroughgoing originalist is the problem at the U.S. Supreme Court of adding rights, guarantees to the Constitution that are not there. In other words, amending the Constitution by interpretation, but the upshot is taking a document with 7,500 words and effectively adding phrases here, adding phrases there. Now, examples, everybody has their own examples, but, until recently you would have said abortion was one, substantive due process, a categorical area, death penalty limitations, establishment clause. Clearly areas where either what the U.S. Supreme Court did was flatly inconsistent with the silence of the text, with the actual language which was there, or just misinterpreted or extended the language far beyond its original public meaning. We all know that problem exists. I think we all agree the last 75 years has been a growth area for the problem. How do state courts and state constitutions help us deal with the problem? Well, it's not enough to say you think the court has added something that's not there. You, of course, have got to prove it. And the very best way, the best evidence rule when it comes to showing the U.S. Supreme Court has added something to the federal Constitution that is not there is to go look at the source code of the U.S. Constitution. And as few people appreciate, the source code of the U.S. Constitution is the early state constitutions. The greatest era of constitution writing in U.S. history, indeed in world history, is from 1776 up to and before the fabled summer of 1787. That's where all the structure is. That's where all the rights come from. There's truly nothing patentable that comes about in 1787, or there's one patentable idea, that of course is federalism, the very topic of the speech, but virtually everything else is cut and pasted from these state constitutions. So first order of business is we think the court has added something to the Constitution that's not there. They've ignored the Article 5 amendment process, and somehow we've got to correct that mistake, and the way to correct the mistake is prove that they've gotten it wrong. Now, Dobbs is a pretty good example of how that works, and I want to illustrate with abortion just how far we went during that period of growth of adding provisions that aren't quite there. And I'll give you 3 cases that you would never kind of think of together, but to me they really illustrate how this worked and why the U.S. Supreme Court currently, in my view, is correctly pulling back on this. So substantive due process is, easily the most controversial, hardest to cabin feature of judicial growth and judicially enforceable rights. Now, the first era of substantive due process, or the key one, is of course incorporating the Bill of Rights provisions. And it's really fascinating to look at how the court originally did that and how careful they were, and then how that care kind of disappeared. So I'll show you 3 cases that illustrate the point. They just happen to be 12 years apart each time. So 1949, they have a case called Wolf, and the issue in Wolf is whether the court is going to say that the due process clause of the 14th Amendment includes a search and seizure provision. Now that's textually quite incoherent, but the court was getting a lot of pressure, and even this is an opinion written by Justice Frankfurter, no fan of substantive due process, or for that matter, incorporation. But when Justice Frankfurter writes the Wolf decision, he says, we're skeptical of saying there's these ordered liberties out there that we, the court, 5 of us, get to find, but we don't have to worry too much in this area because we have so much evidence that America has a norm of prohibiting unreasonable searches and seizures. What is his best evidence? The reality that every state in the country had a constitution that directly prohibited unreasonable searches and seizures, or as in a few states, had a right to privacy provision that was designed to do roughly the same thing, if not more. So he's able to say in 1949, maybe substantive due process and incorporation is problematic from a judicial, power perspective and a separation of powers perspective, but there's not a lot to worry about here because the norm is so uniformly reflected throughout American society as proved by the state constitutions and the way the state courts enforce them. Fast forward 12 years later, they now have another search and seizure case, but this time it's about whether to nationalize the exclusionary rule. Here again, they have no textual support, they have no historical support. All they can look at are modern norms, obviously an evolving theory of constitutionalism. In MAP in 1961, they say half of the states have an exclusionary rule. So we go from a world in which we need to have evidence in every state, that suffices. MAP, half of the states have an exclusionary rule. That's good enough for us to nationalize an exclusionary rule for the whole country, adding that right. Fast forward 12 years later, we get Roe. Guess how many states in 1973 protected a right to abortion in this country? 0. Guess how many states in this country protect a right to abortion with the word abortion in their state constitution today? Still 0. So, that is an evolution. Let's try to take it out of the 3 rights I mentioned and just think of them as the court has the power to create rights A, B, and C. A, they create because everybody already does A. B, they create because half does B. C, they create where no one does C. That is an astonishing growth in judicial authority, you might say audacity, in terms of their authority to identify and add new constitutional rights that aren't in the text and aren't based in history. So just in case you're wondering about my actual views of substantive due process, let me leave no room for doubt and tell you what I really think of the doctrine, and feel free to challenge me, and I'm sure there's some that want to and are already thinking about it. But please think of this hypothetical when you challenge me. So what the substantive due process with respect to enumerated rights, what's in the Bill of Rights, is, okay, a lot of water over the dam, let's let it go. But when it comes to substantive due process and unenumerated rights, that would be abortion, that's where I really get off the train. And I want you to think about it this way. Imagine tomorrow that I started using coin flips to decide my cases. Now, coin flips we use in a lot of ways because they're actually neutral. We don't like it that they're arbitrary, but they have a neutrality to them that overcomes that. But we use them for things that don't matter that much. Who gets the ball first in a game? Yes, it might be nice to have the ball in the second half. It might be nice to be going down the field or, in your home end zone, whatever it is. But it's not that consequential how we use coin flips at the beginning, say, of football games. But imagine if I, getting a little tired of all this hard work of being an appellate judge, decided I've got a really neutral and very efficient way of deciding cases. When I look at the briefs, I don't even look at the briefs. I just look at who the appellant is, flip a coin, heads, the appellant always wins, tails, the appellee always loses. Now that is very principled, it is very neutral, but the arbitrariness with respect to who wins $2 million or who goes out of jail, stays in jail, that would trouble us. And I hate to use the phrase articles of impeachment in connection with a sentence that has my name in it, but I'd have a hard time defending myself if someone said, Jeff, if that's how you're deciding cases, it seems to me articles of impeachment are in order. And sad to say, even Bill Pryor could not get me out of that jam. I think I would be in trouble. Here is my objection to substantive due process that does not relate to an enumerated right. Coin flipping is more fair. Find me a substantive due process unenumerated right case where the justices that identified it did not approve of it as a matter of their worldview and policy view. You did not have a neutral chance to win those votes. That is not a doctrine we should be embracing, and every time we get remotely close to something where coin flipping is more fair, it's really time to blow the whistle. That was lament number one, the addition problem. Lament number two is the subtraction problem. Just as it's offensive to add something to the text, to the Constitution that's not there, it's equally offensive to take something that is there, and it's as if the confirmation process is not only giving you a pen to add words to the Constitution, it's giving you the capacity to erase them once you're on the court. Now that, lots of things can come to mind there. Right to bear arms, free exercise until recently, although some people that think with Smith there, that's a problem. Certainly separation of powers and federalism has been a problem. I mean, think non-delegation, think of Chevron, areas where it's easy to wonder whether what the court is doing with respect to separation of powers is consistent with either the text or the original public meaning. Now, the subtraction problem is, it's no less offensive. I suppose you can argue at least it allows democracy to operate, so that's a fair point. But this term with Bruen is such a wonderful case for trying to deal with the subtraction problem, because Bruen is clearly a case where 6 members of the court are saying, listen, you guys put the Second Amendment here, it's our job to enforce it, after that it's up to you, but that's all we do here. We're lawyers after all, and Justice Thomas's opinion is both text-based, history-based, tries to do as little as possible with judicial inventions like tiers of review, and just says we're going to historically look at this. The facts in the holding are, I think, actually not that hard a case. I mean, if you have a Second Amendment right to have a pistol for self-defense in your home, surely you have a right to take it outside the home to make sure you're actually shooting the right person, i.e. going to target practice, which was all this law did. It limited your ability to carry the weapon outside the house to something as simple as target practice or learning how to use the weapon carefully. So that one, I think, still leaves plenty of room for innovation. I think at the end of the day, there is still going to be a difference between gun regulation in Wyoming and New York City. But it does raise this question for we judges, and that's the question of whether we have the skill set to do the history well enough to have confidence that what we federal judges are doing when it comes to identifying these constitutional rights, they really are rooted in the text. I mean, if I'm upset about addition and subtraction, I have to defend judges' ability to do history, and you're hearing lots of arguments, lots of books. I mean, Erwin Chemerinsky has one out really just questioning whether judges can do this at all. Well, a couple thoughts on that. One, we lawyers may not be trained historians. I think we should start with that premise. But law is, for want of a better word, entirely backwards. Everything we do looks backwards in time. It's all historical. It's always about a statute previously enacted, facts previously occurred, a common law precedent from a time ago, and then constitutionally looking at a constitutional provision that's situated in a certain time and place. So it's not that foreign to us. That's point number one. I think lawyers, by training, learn a lot about understanding history, different eras in American history. So that's point number one. Point number two, the idea that we can't do historical disputes, but we can do med-mal cases, complicated securities cases, antitrust, patent cases, strikes me as quite absurd. We're asked to do a lot of things we have no right doing, given how little knowledge we have of the underlying area. Why do we decide we can do this? Well, we have very good lawyers that are going to join the debate. They're going to find out what the decision point is, and by the time we're actually deciding something, most of the chaff has been eliminated, and there is something for judges, generalist judges, to sort out. So I actually think if we're going to do all these other things, I don't think it's that hard for us to figure out the answer to an historical debate, and if need be, get amicus, trained historians, to come in and weigh in on both sides of it. But I have one last idea on this history point, and that is that it does deserve humility, and I do hope that we federal judges in particular are really careful with this. Otherwise, 10 years, 20 years from now, we're not going to be able to say what Kevin Newsom said earlier, which is, when you do this carefully, it really does come out in all directions. And I hope that's what we're going to see 10 years from now. But one way to check that, in my view, is to remember how the early state court judges did judicial review. There's a lot of talk about Marbury versus Madison in the last panel. That's all well and good. But let me just tell you something. In American legal history and American constitutional judicial review, had there been no John Marshall, had there been no election of 1800, had there been no Marbury or Madison, we would have had judicial review in this country. And the reason is because the state courts were already doing it. That's why Hamilton talked about it in Federalist 78. I mean, there was no need to talk about it in the Constitution. That was an understood practice. Why was it so understood and so well established, even though we borrowed so much from England, which had a, quote, unwritten constitution? That's because England had something else, which we had from the outset: superior laws and inferior laws. That was very much true in England, and so it was not a problem for us to say the Constitution's a superior law, a statute, executive branch order, inferior law. All judicial review was not, it should never have been called constitutional or judicial review. It should have been called conflict of laws. That's how they thought about it. It was just conflict of laws. And what did the early judges do, and what do I happen to think was the right attitude for judicial review? They said you are duty-bound to honor the superior law. That would be the constitutional law. So there is no choice on judicial review. If you know the meaning of the superior law, you have got to enforce it. So that's one part of the attitude, but they had another part of the attitude which shows up in all these early cases. And that's that if they could avoid the conflict between the Constitution and the statute, for example, they always tried to avoid the conflict. And the last thing, and this comes from John McGinnis, is they weren't going to invalidate a statute unless there was a clear rule that emerged from the constitutional provision. So they really wanted a clarity requirement there. That, to me, seems like another great way to deal with what we'll call the history problem. And I will say, we do need an attitude of humility when it comes to figuring out what a 1791 phrase meant. I mean, I just don't understand how you can't think about it that way. And what we should be remembering is we're construing a document that is very difficult to change. I would say essentially impossible, which I'll return to in a second. And we really ought to expect a clear constitutional rule that comes from that text or that historical research. Otherwise, it's up to democracy. So once again, the subtraction problem, the subtraction lament of a federal originalist would be, look at what the state courts did with judicial review, look at state court practices, and of course, the blueprint of every federal constitutional individual rights guarantee would of course be a state constitution. Lament number 3, stare decisis. The originalist this is what drives most originalists to drink. They cannot understand how these two things can be true. That on the one hand, the court in, say, the 1950s or 60s would not follow the original public meaning of a 1791 provision, all right? It's ratified in 1791, it has a clear meaning in 1791, and the US Supreme Court in the 1960s or whatever doesn't follow that original fixed public meaning. They announced their 1966 decision interpreting this, and then through stare decisis, frankly another form of magic if used improperly, the sacrosanct language is the 1966 interpretation and not the 1791 document. I mean, that is a form of magic. And that's a very frustrating reality for originalists. Now, we have one justice on the US Supreme Court for the last 30 years, happens to be your circuit justice, which has looked at that problem and said there's just one answer to this problem. And the answer is that if the underlying constitutional decision is clearly wrong, I just don't care what the consequences are. I don't care what the reliance interests are. We have no business dignifying any longer a clearly incorrect decision because it's just a power grab and we've got to return the power. That's just what he's saying. Now, that is the most principled view of stare decisis that I know in American history. The problem, and I'm not, listen, put me on the court, I'll be a second vote, but it would still be 2. You're three away from a majority, just to help you with the counting. We do need a backup plan. Originals need a backup plan for other ways to think about stare decisis if the Justice Thomas view is not going to prevail. You're not going to be surprised. It comes back to state courts and state constitutions. So the backup plan for me is that courts should not hesitate to say, you added something that is not there, you subtracted something that is there. But here's what courts have got to spend a little more time talking about. What does the addition and subtraction mean? What does that mean? What that liquidates to is you circumvented Article 5 of the US Constitution. The founders were aware that they might not have written a perfect constitution, and they were aware times change, and that's why they had Article 5 and said, if 3/4 of the states want to ratify a new provision, go for it. And by the way, the Articles of Confederation was 100%, so it was very difficult. This was 75. And we had for about 150 years in this country a culture of amending the Constitution to deal with things we hadn't appreciated at the outset or to deal with mistaken interpretations. That's how that originally worked. But the key point is to remember what an addition or subtraction case is. You've circumvented the 3/4 requirement. That helps you deal with the stare decisis problem. My view is a court should be very comfortable saying that was an error, but in law we have something called harmless error. And sometimes errors have become harmless over time. Maybe an error is harmless because it's actually not going to affect the party. Well, there are some constitutional decisions of the US Supreme Court that added things or subtracted things that really would not have significant consequences today if they were overruled. The country has moved on. Another way to put it is hypothetically, you would not have trouble getting 3/4 of the states to amend the Constitution. I like this harmless error approach, again, as a backup plan. It actually it really helps you think about Dobbs, the abortion case. The astonishing thing about Dobbs is after 50 years, I mean, a lot of people were thinking 50 years counted in favor of leaving it in place. I actually think it cut the other way. 50 years is a very long time for the people not to decide this has been settled. And if there's one thing we know about that issue, it's one thing we've seen since the decision, it ain't settled. This is a very difficult thing to sort out. It's being sorted out in lots of different ways, state by state. There are other decisions of the court that you might have said added things that weren't there. The gay marriage case could easily be an example in that category. But that would be one where it's a little harder to say how harmful it is. I mean, I get the point that it's one I could see revisiting. I can see saying it's error, but you have to wonder if it's the same kind of harmful error that a decision like Roe or Casey was. So the third thing, Lament, stare decisis. Whether you agree with my backup plan for dealing with stare decisis or not, I'm very confident it's the right thing to be doing in this area is remembering what it is the court did. They circumvented Article 5. That's not right. That's taking power that's not theirs. The power ought to be returned when it can, and my only thing I'm saying is if it's no longer a harmful error, maybe there are other fish to fry. All right, last lament, and it'll be fairly short, and then I'd love to get questions, challenges, you name it. The last lament for an originalist, and it's the easiest, is the growth in the footprint of the federal courts. You can spend the rest of your life reading about 1776, and you're not going to see anybody saying, the reason we need to break from Britain and this horrible monarchy is to create a 9-member court where 5 members of it have life tenure and can decide things that are basically not correctable and make some of the most significant decisions in American society. I mean, that is just so foreign to our founding, so that anyone that takes originalism seriously has to agree that while the rule of law requires judicial review, requires courts to enforce constitutional rights, something has gone amiss when it comes to the footprint of the federal courts. I'll put it this way. This is the 3-legged stool that has existed for the last 75 years, and I find unsustainable for the next 75 years. Something will give. You have a federal court system that has exercised judicial review in a more muscular way than any country in world history, leg number 1. Leg number 2, construing a document that is harder to correct than any Western democracy. I think Australia might have 75%. No one else comes close to 75%. I mean, that's magic, right? You construe something in a muscular way and no one can correct it. Third leg of the stool, they of course have life tenure. And the composition of the court cannot be changed except by the randomness of who dies when, who's president when, who retires when, who doesn't. Some part of those three things will change in the next 75 years. I see no way in which that stays the same. Guess what I think might be a better approach? State courts and state constitutions. And this explains one way to think about how the federal footprint and constitutional law footprint might change going forward. None of that three trio does not appear in any state in the country. You have had state courts that at various times have been pretty muscular in their judicial review, but almost every state constitution in the country can be amended by a 51% vote. So to the extent those are, quote, activist state courts, the people apparently like it because they're not responding by overruling their decisions. Or they are, in some cases, they are overruling their decisions. Only one state in the country has life-tenured federal judge, no age cap. Oddly enough, it's Rhode Island. Isn't that the strangest, the biggest, the smallest? One of them got it right. It's not the U.S. So everyone else has retention elections, partisan elections, nonpartisan elections, age caps. So you not only have this remarkable disparity. I mean, think about it this way. If I told you I had a policy idea in the abstract, and I had the support of people from Alabama, Florida, Mississippi, Ohio, Colorado, California, you'd say, Jeff, if you got those folks, you can do anything in this country. They all agree on amending constitutions, caps on judges, retention elections. The same Americans they've spoken with what they want in their state constitutions. They do not want this. Do they really want this other model for the federal courts? It's really hard to believe that that's going to be sustainable when the same group of Americans is doing something really different in this other direction. And my last point, and this is where I'm ending, is Brandeis had a great insight when it came to dealing with new policy problems. And his insight was let the states be the labs, the pilot projects, whatever you want, or whatever your metaphor of the day is, and let them try to deal with this new problem, opioids, data privacy. And if a winning insight emerges, another state can do it. If a truly winning insight emerges, you nationalize it. If no truly winning insight emerges, you have customized approaches throughout the country. Americans embrace this. We don't embrace a lot, but we do embrace that feature of federalism, that there's nothing wrong with different state legislatures having different tax rates and just different approaches to these problems. But somehow, with the court system dealing with equally vexing problems, we went to this model for the last 75 years of nationalize, one size fits all from the national government on down. I suspect my cynical reason is the incentives were there. It was what the interest groups wanted. If you're an interest group, why wouldn't you want a constitutional decision that can't be corrected and has life-tenured justices? It's a beautiful system if you win. It's horrifying if you lose. And the problem we face right now is it's a half and half situation. But what I don't understand is if the state court judges are the ones whose decisions can be corrected the most easily, the personnel can be replaced if the people want, they have a history of not overdoing it when it comes to judicial review, why aren't we looking to them to be in the front lines of judicial innovation? We have no problem with thinking about state legislatures that way, and I just don't understand why we're not embracing that insight and doing the same thing on the state model. I'm no fan of substantive due process. You heard me on this. But, if we're going to have wolf decisions where the court nationalizes something that all the state courts do, all the state constitutions do, it's just not that harmful an error. But what we're doing, the way we're doing it, is really harmful. I think it has a lot to do with our polarization and the resentment a lot of communities in this country feel. And heck, I can think of a presidential election that arguably turned on one vacancy in a 9-member court. I mean, how astonishing is that a presidential election would turn on one vacancy on a like-membered court? I mean, it really makes you think about whether we're doing this the right way. So to me, you lawyers out there, go to your state courts. I mean, that's where the action is. And one of these days I'm going to join them. I love the federal bench, but this is just one long 20-year audition to get to the state court bench. So thank you so much for inviting me. It's so wonderful to be here with you. I have so many fond memories of Birmingham chapter events in particular, including the one I did from the Admirals Club in the Charlotte airport, which had to be a first in FedSoc history. But thank you for inviting me. Bill, thank you for your warm introduction. Thank you for your friendship. And now, please be good Federalist Society members and challenge me, which, I did love being an advocate, and this is my chance to go back to that phase in my life. So thank you.
All right. You got almost to the end without triggering me? And then you triggered me?
Oh, darn.
You didn't say I couldn't ask a question.
Is it stare decisis that I got you?
No, it's when you said, well, why aren't we looking to those state judges to be the innovators? And I thought to myself, well, there's an obvious answer to that, and it's because structurally you just laid it out. They're so much more in keeping with popular sentiment in their respective states because they don't have life tenure, their constitutions are easier to amend. There's not the same kind of hydraulic pressure to do that. And frankly, that really, to me, makes more the earlier pitch that you were making, which is maybe we need to rethink some things about the structure of the federal courts. But when can I get you to stop suggesting that the answer might be state judicial activism?
Yeah, well, so I sometimes make the mistake of trying to speak all the languages of the folks listening, and you're definitely a one language guy, and I as an advocate, I sometimes would think I really want to get all 9 votes, and so I'm trying to speak all 9 languages. I do not agree with judicial activism, and if I were a state court judge, and as you can tell, I'd love to be, I can't imagine myself deciding cases very differently than I do now. It might affect me, actually. One thing might affect me, that in a close case, you should ask the risk of error. I feel like we federal judges do not ask, that's the question, not what's right sometimes, but if it's really hard, what's the risk of being wrong? And in the state courts, the risk of being wrong in a constitutional case are not the same. So that might be the one area where as a federal judge where, now as middle management judges, we can be corrected. But at the U.S. Supreme Court, the risk of error is really, really high because it is so difficult to amend the federal Constitution. So maybe that might affect me a little bit. We're on the same page. I agree with you. Yeah. But I want to say this.
Doesn't it really cut the other way, though? And that is, and at the founding period, one thing you didn't mention was that if there was a conflict, the conflict, not only did there need to be a clear rule, there really just had to be no doubt, right? They wanted to be kind of free from doubt in weighing in. And it seems to me that if you employ the same kind of framework at the state level, because it's so easy to amend the Constitution, if the judges don't weigh in on something, it's okay. The people in the legislature can take care of it very easily. But it actually suggests that they should not act more as opposed to act.
Well, that is true. I guess I'm not sure. I think state legislatures, it's hard to generalize, are as responsive or unresponsive as Congress. I'm not entirely sure about that.
Every time when they would show up in Montgomery, I would look around and I would say, it was never a happy time when the legislature came to town, but I always did think this: they are representative of the people of my state. I always felt that.
Well, how about this way of thinking about? I'll
They
take.
were.
I will not. I don't think I did use the word judicial activism. By the way, I think you used that to characterize me. So that's a little bit of a trick. But classic judge question. Switch it around a little bit and see what the lawyer does with it. So, but here's an honest way of thinking about this, or for me, it seems a fair-minded way to think about it. Compare these two things. Do this experiment in your head. You get someone from Venus, they don't know anything about how judicial review in this country works. And all they can do, they have to tell you how it works in their report. And their only evidence is confirmation hearings of federal judges and stump speeches of judges running for election, okay? If that's their data box, what they're going to say is those fellows, Scalia and Thomas, clearly won, because what judges do is they just interpret law, they don't make law, law has fixed meaning, the original public meaning is where it's at, and no one will say, yeah, no, as a judge, if there's a big enough societal problem, I'm going to fix it, and constitutions and words do change. No one says that on the stump, no one says that in confirmation hearings. So if that's your only experiment, you say, voila, that proves everything else is idiocy. But now we have to be fair about it, we have to now do a second project where your person from Venus comes and says, okay, tell me again how judicial review works, but now here's your evidence. Read state high court opinions and U.S. Supreme Court opinions. That is going to be a very different paper, because what that paper is going to say is there have been times out of convenience, policy preferences, where state and federal judges, if you ask me, it's because they're human beings, they're mortal, and it's tempting to want to do what seems to be the right thing, or it's really tempting to try to fix a bad problem. That is human nature, and so that will be historically how they err. So the better way to put my state versus federal point is if our fate, our destiny, are judges who will eventually always be tempted to get beyond their authority, shouldn't more of that happen in places where it's correctable by the people and less of it in places where it's not correctable by the people? That is my real pitch. It's that federal and state court judges are equally human, equally tempted, and it's their destiny to make mistakes. And some of the mistakes are going to be anti-democratic, inconsistent with what the people wanted in any of their constitutions. And so that makes it, in my view, more wise for the state courts to be the innovators. And by the way, on the numbers of cases, our job is so privileged. The number of cases in the whole federal court system in a given year is about 400,000. 400,000 for the whole country. Guess what it is for the whole country in the state courts? It's like 40 to 50 million. 40 to 50 million versus 400,000, and all we want to talk about is the 400,000? I don't understand it. It's like a bunch of lawyers who don't want work.
What I don't understand is why you want to be a state court judge.
It's because this is personal. I almost did not take the state SG job. I don't think I've told you this story. I almost did not take that job. God forgive me. I thought I was above it. I went into that government office building and I noticed they didn't dress as well as the people at Jones Day. I'm like, where's the free coffee? Where's the free soda? I'm above this. I should be stricken for that. I almost did not take the job because I literally thought I was above it. And I'd gone to Ohio State Law School. How could someone who went to Ohio State Law School think they're above anything? And that's what I thought. And my wife, thank God, said, Jeff, but you really want to get into court. I just know it. You're not getting into court in private practice. Right. You should take this job. Where are my best friends? All from that. So, yes, I want to be a state court judge. Mm-hmm. Heaven is working for states. All right, go ahead. Nathan, a former student.
Yes. You mentioned earlier the historical challenge that originalism faces in seeking to understand original meaning. How would you respond to someone who raises the fact that in the realm of state constitutional adjudication, often the historical challenge can be much harder in light of, in most states there are less historical documents available, certainly less scholarship working to understand the original meaning as opposed to federal constitutional adjudication, so less resources to do the work of originalist state constitutional interpretation.
Yes, so it's hard to generalize about this, and I'm not going to doubt that you've come across some states where the historical research is difficult. But in the main, it's actually easier. And the reason it's easier is, we've had about 300 and something successful state constitution conventions. And of course, a lot of them are more recent. The key times are Jacksonian, populism, post-Civil War, progressive era, and post-Baker versus Carr, one person, one vote. You had so many constitutional conventions then. So the point I'm getting at to start is the historical research is not quite as historical, all right? So that's one thing. Thing two, which really dignifies your point, and frankly mine, we have paid so little attention to state constitutions that until the last couple of years, No one is bothered to track this stuff down. I mean, they obviously have the documents, but they don't have the historical debates. But thankfully, a bunch of folks are trying to do this. And so whether it's corpus linguistics, there's actually quite a few groups now putting online all the historical records of the different state conventions, all the way back. Now, there are some random states where, like, they had a flood in Arizona in 1924 and they lost everything. So there are some bad situations. But for the most part, what your experience is that no one's bothered to help you by pulling it all in one place. And I think that is really improving right now because, frankly, a lot of scholars are realizing state constitutions may be where the action is going to be. And even if it's not always, at a minimum, it's become so relevant to the federal constitution. I mean, that probably is what got this going, is people wanted to figure out the original public meaning of the Second Amendment. How do you do that but look at the original state constitutions and how they described it and what it meant? So the point's really well taken. There are some places where they haven't gathered it or they had some disasters and lost some things. But I think you're going to find eventually it's pretty well put together. And my hope is as state constitutions and state courts become more important, there'll be more incentives to do that. But I think a fair amount of that's being done.
Well, the other point that Justice Peterson in Georgia points out is that in states that have multiple constitutions, many of those provisions are readopted verbatim from one era to another in the eras that you were outlining. But in the interim, the state courts have settled some ambiguities in the meanings of those provisions over time in a way that you could say at least, though it may not have been as clear what the meaning was originally, that once the courts liquidated that meaning through precedent, and then it was readopted verbatim by ratifying conventions and the people of those states, that too gives you a better record than you get at the federal level, right?
Yeah, there's that, and I would also make the point, and this is a chicken-egg problem. I think I mainly blame the state lawyers, not the state judges, but a lot of state courts have not been presented with independent state constitutionalism arguments, even just based on the text. I mean, they've got the text right in front of them. And so what have a lot of state courts done? They've lockstepped. They've just followed the federal doctrine, removing any incentive to do the historical research. And so I really put this on the lawyers. I mean, it's so strange. I mean, who misses a free throw in a two-shot setting and doesn't take a second shot? And that is what so many state lawyers do in this country, is they bring their federal claim and they say if that loses, maybe we take a second shot with no argument, or maybe they don't bring it at all. So, state judges are referees, they're not players, and they need you all to make the argument. I mean, you have the text. I mean, just read Article 1 of the Alabama Constitution. I mean, a lot of those provisions are textually distinct from the federal Constitution. There is no way they should have the same meaning. That's nonsense to me. I just don't understand how you would think different words have the exact same meaning. That's the sign of a state that doesn't believe in its own sovereign authority, and a state Supreme Court that doesn't think it's the final say of what that sovereign document means. Yes?
So you identified a three-legged stool. The legs were...
Another student. I love this. Go, if you will.
So the legs were 1, muscular enforcement of constitutional rights, 2, an unamendable constitution, and 3, life tenure. Your proposals on which legs to fix seem to be on 2 and 3, which are the legs that are actually in the Constitution. Are there ways to patch up the first leg of that?
Oh, so I do not believe that. I am a big fan of the leg one approach to this problem. So I don't care for substantive due process, particularly with respect to unenumerated rights. That would be a nice fix. I like the attitude of federal judges being humble when they do these constitutional cases, remembering the risk of error, that it's almost irreversible. So I actually think the courts, the federal judges, are in the best position to shrink the footprint. That is what I think, and you're quite right. The other two would require a constitutional amendment. Now, that said, I mentioned earlier that we did once have a culture of constitutional amendments in this country, and I think it would be very healthy to return to that. Political parties used to think that if you were giving women the right to vote or for or against prohibition, it was politically advantageous to have to go to all 50 states. They realized that that was a beautiful political thing. They knew they were in the right, and they knew that could maybe help them get power in the state legislature, state governors, state courts. They weren't afraid, they didn't think of it as a problem. They thought it was politically advantageous to take their cause throughout the country. And that just disappeared. That has disappeared in this country. Arguably, it ended with the ERA, which came up 2 votes short. So one thing I would like to see is either that culture return or incentivize its return by getting a constitutional amendment that says we go from 3/4 to 2/3. That's only a difference of 4 states. That's not making constitutional amendments that easy. It would have made a difference in the ERA for what it's worth. But I think that would be, I actually would really support that. I think 3/4 is too high. For what it's worth, I think 51 is too low at the states. I don't think any state should be below 55%. And 55% would get rid of, you guys have a very big constitution. I mean, I can't remember where Justice Black came from, but Justice Black used to say, I do remember where Justice Black's from, but Justice Black used to say I could carry the Constitution around in my front pocket. And here in Alabama, our state Supreme Court justices, we're talking like one of the bigger U-Hauls. It's gotten very big, and you have an initiative the way Ohio does. That explains some of it, but a 55% threshold would I think really help and ultimately dignify these state constitutions. But fundamentally, I think the federal courts really could do well to pull out a little bit and not be making so many significant decisions in American society. Or if you're going to make them, be more patient and wait for the states. I mean, that was really one of my messages, where I'm trying to say for those who like judges ruling their lives, let's have the federal judges be a little more patient before they decide to do it. A few more inputs, make it a little less obvious that they're doing something that might be very inconsistent with what most Americans want.
We don't have an initiative.
Oh, you don't have an initiative?
No, but we have, it's just 51, it's just 50% plus 1.
Who's doing all this? This is your local government. Is this your local
Yeah, a lot of
government?
it has to do with local
Yeah.
government. That's exactly right. Yeah, home rule problems.
We're going to see a lot more home rule problems in the future as cities get more progressive and state legislatures get more conservative. That's going to be a real interesting line of battle. And actually, like federalism, potentially helpful. State legislatures can say, go do what you want in Birmingham.
Yeah, you haven't met our state legislature.
Not yet, not yet.
Questions? Well.
Oh, yes.
Good deal, Ashley. Good deal.
I love it.
I'm not sure if I agree with you or not, but I might not agree, so it's worth asking the question. I want to approach the law from the Holmesian bad man perspective, right? Because it's all well and good if state judges are competent and faithful to the Constitution, both state and federal, but to the extent that you have activism, which was sort of the kernel of Judge Pryor's question, I have more concerns with your proposal. So let's take the addition problem. Why wouldn't a state judge who wants to enshrine something into law that doesn't belong there, that is difficult to change through the political process that the state has set up, just say, I'm interpreting the federal Constitution, and so all of the problems that you said about 3/4 and it's difficult to change, that would come into play. I suppose you could have the electorate throw those state judges out for being activists, but it's pretty hard to get state judges thrown out with these retention elections when you just focus on one issue like that. And then with respect to the
So just
subtraction-
on the first one, you're making the point they could end run the problem by ruling on federal constitutional claims?
Yeah, just like the Warren Court, they'll make up a federal
Yeah,
constitutional
but I mean, if they're doing
right.
federal, the U.S. Supreme Court can knock them down.
Well, now you're relying on the U.S. Supreme Court to fix the problem, which is the problem in the first place.
Well, but that's their problem. I mean, they're in charge of the federal Constitution, and if they're adopting the right approach, clear historical source, they will correct those wayward decisions. But I want to get your second question out, but I also want to make sure we're careful before it looks like I'm agreeing in any insulting of state court judges. I think historically, the state court judges are the winners. I mean, ask yourself what it looks like to take state constitutions on the left side of a page, and on the right side have all the state interpretations. And then the game is like a game of telephone. How close are they? How close is the language on left side, interpretation on right? And now compare federal courts. Language left side from the federal constitution, interpretation right side. I will bet, I don't have as much money as you do, but I will bet a lot. I will bet a lot that the states win that game hands down. So even though they're elected, they're the ones that have been following law. We should have trust in that. We should think that's good. I think the incentives are to go to the life tenure judges interpreting a constitution that can't be corrected. That is gerrymandering. I mean, we all agree gerrymandering is horrible, extreme partisan gerrymandering, but somehow we love it when it's 5 justices on a life tenured court, and we call that judicial review. Isn't it gerrymandering if they're adding and subtracting? I mean, it's like the worst form of gerrymandering. And yet we, as a people, have not figured this out and just called it. That is gerrymandering. And we all say gerrymandering's bad, but not when it's life-tenured federal judges. So second question.
Well, my caution to you is that if you push it down to the state level, the people like me with money are going to start trying to influence the state judges to gerrymander in the way that we don't like, the way the Warren Court did.
And I know it, and I love that because it'll get fixed when you get them to do something they shouldn't have done. It'll be corrected with a constitutional amendment. You'll win, you'll get your judgment, and then after the fact, the constitution will be amended. We're all good.
And the second question is, how does pushing it to the state level solve the subtraction problem? Because as you say, the subtraction problem is one that at least maybe isn't as bad because it's subject to the democratic process, but to the extent that there's a right that might not be popular that's supposed to be enforced, and the minority who can't get the political process to work in his or her favor is being deprived of something that is supposed to be subject to a 3/4 until amended mechanism where that's the way the document's written, I don't see how state judges are going to do any better at the subtraction problem precisely because they are subject to the political machinations that you note as a virtue about shifting things back to the state courts.
Yeah, I mean, I think there's one, I actually fundamentally agree with this point. I mean, just the one reason you still use state courts for subtraction is just, it's evidence that it was subtracted, right? The state constitutions prove that the Second Amendment is an individual right to bear arms, not a collective right connected to a militia, right? So that's how the state constitutions helped deal with the subtraction problem. But what you are right about, and this is it's a really great point, there's nothing the state courts can do, for example, with the problem of the federal courts not attending to separation of powers. I mean, there's nothing, so you're right, that if you have federal agencies exercising power that the framers in the Constitution would not have contemplated, running to state court, there's no way it fixes that problem. I mean, the individual who is regulated by a federal agency, for sake of argument, exercising power they don't have, you're totally right about that type of subtraction problem. Now, the only thing I would say, which I love about administrative law and separation of powers, and this is another reason to have faith in state courts, that's a really fun story. The state courts have not had problems with letting agencies get undue power. They enforce the non-delegation doctrine at the state level. Almost every state in the country does not give Chevron deference to their agency interpretations of statutes, so they're the ones that understand the Marbury power. We're the final ones to decide the law. So it's really interesting. I do think that's a good example of where there's no great subtraction solution by going to the states, but I do want to point out state courts have been really good on administrative law and paying attention to their documents, which are very clearly premised. And let's separate as much as we can because human beings are so fallible.
I thought one point you might make, though, was that the politically unpopular right, that minority's right that Ashley mentioned a moment ago, that it's hard to get the political process, at least at a national level, to adopt. If it's shifted to the states, the dynamics are very different. As you pointed out, and one of the points you made in that Violence Against Women Act brief is that federalism is a counter-majoritarian right. And when it is pushed to the state level, there are some things that are quite popular in Alabama that might be a minority position nationally, but could actually get done through the political process. And then the American people can vote with their feet to go to the jurisdictions that adopt the rights that they favor. So what might be a minority on religious liberty or this or that right, whatever it might be, you can move to a jurisdiction that better reflects your values.
Well, I mean, Bill, this question just goes to the briefs we wrote in Garrett and Kimmel.
Yeah.
I mean, so the whole point in those cases was, how is it that the state of Alabama is unwilling to be subjected to money damages actions for violations of the ADA or the ADEA, and the government's making all these points. You can't trust states. They're never going to look after the disabled. They're never going to look after the elderly. And the whole point of these briefs was to say, are you kidding me? The ADA comes into being in 1990. Every state in the country protected against disability discrimination before 1990. All right, it was the feds that were the discriminatory group. So I feel like sometimes we have these assumptions which really grow out of Jim Crow. We don't want to forget the Jim Crow chapter, but it leads to this false assumption that states can't get counter-majoritarian rights done correctly, and that just is not necessarily so. And I think there are many examples where it's really quite the opposite. My more important point is that in this era of polarization, why are we doing one size fits all? That's crazy. In polarized times, let neighborhoods, communities work it out. If it's a great idea, let it grow. That is the way, ground up is the way to handle things in a polarized era. It is not top down. And I think that is what we're seeing, too much top down, and therefore administration's back, we get rid of it, we add it, we get back. You never stabilize anything with that kind of a power grab approach to government. If you do it from the ground up, you compromise, you find something that works for everybody, and you move on. And I just don't know how we lost sight of that insight. It's as American as it gets. Well, it is so great to be with you. We're giving you a little time back, I think. Don't say the Federalist Society wasn't good to you.